Hi, Caitlin, Natalie, and Samantha. Wanted to offer you some feedback on your analysis of the case Munn versus Hotchkiss School. Um, when I look at your message map, I'm looking for your interpretation of a clear message that school leaders should take away from the case. And I think that what you've done is provide a probing question as to what is that interpretation. One of the things that this case is informative for school leaders is that schools do have a duty to warn students about foreseeable dangers and to take reasonable steps to reduce the likelihood of injury through proper supervision. And in the Hotchkiss case, the court was really clear that there was a failure to warn regarding foreseeable danger and to employ protective measures as far as proper supervision. While I agree with your point that you made early on in the presentation, that it is unreasonable for school leaders or school personnel to anticipate all dangers, but they were clearly negligent because they breached their duty to supervise. They let that little group go down the path, even though they pointed them in the right direction. I think Kara was 14 or 15. As we all know, you have to maintain sightline supervision with students even at 14 or 15, and some may argue reasonably, particularly at that age. So they did breach their duty to supervise, and if they had been supervising properly, they would have been able to mitigate that risk. Moreover, the directions provided by by Hotchkiss, the Hotchkiss school in the beginning, as far as the packing list, the provision for bug spray was just mentioned incidentally as something they may want to take. They also didn't provide accurate information relative to pointing to the correct website to provide information about the part of the country the trip would take. At minute 4.35, there was an assertion made in the presentation that Mrs. Yu couldn't be held accountable. And that really is inconsistent with the holding, because the court did find in favor of the plaintiffs and made them an award of, as you note, what is it, $41.75 million, of which 38 or so was in non-economic damages. So the court clearly found that they breached their duty relative to supervision and to warning against foreseeable dangers. I really appreciated the discussion you had around point 2 because you illustrated your understanding of how school officials sometimes have to weigh equally important points in a dilemma. And that was so clear when you were talking about the risk to faculty as far as personal liability versus the benefits to students when taking field trips. One thing for you to keep in mind is that when school officials are performing their duties in a reasonable manner, then their shield of qualified immunity will remain intact, and they will not find themselves liable either personally, nor would they find themselves liable on a professional level. You referenced the David versus New York case, and one key difference between that case and the Munn versus Hotchkiss case is that in the David versus New York case, those kids were properly supervised on the hayride. And while the little boy, his eye was injured, he was supervised, whereas, as you note, in point 2, at about 10 minutes, 43 seconds, Kara and her little group, they went down the hill unsupervised by themselves. While they were pointed in the right direction, the path to take, they were just left to their own devices to go the way they wanted to. And like a lot of teenagers, decided they were going to do something inconsistent with the directions. It's important for you to know that schools are under a duty to adequately supervise students in their charge, and they will be held liable for foreseeable injuries proximately related to the absence of adequate supervision. You're right, a school is not an insurer of the safety of students. For example, schools don't have a duty to protect, but they are obligated to exercise such care over students in its charge that an ordinary, prudent person would in a comparable circumstance. And in this case, that was not in evidence. And that's why the case was won by the plaintiffs. The case, and this was not included, but there was a lot of discussion in the case about the Connecticut Supreme Court looking at this and either affirming or remanding these decisions. As it turned out, the Connecticut Supreme Court did look at the case and they did affirm the decisions. So I want you to take away from this the fact that schools do have a duty to properly supervise, and they have a duty to warn against foreseeable dangers. It's not reasonable that school officials can anticipate everything, but it is expected that school officials will make reasonable decisions. All right? Thanks so much for unpacking this case.